What about Tuesday? Anything that he said happened between the two of them on Tuesday?
Tuesday, Cedar came down the stairs, asked him about getting a job or going back to school again. He said that Cedar had a knife in her hand, and that he came out of his bedroom. She was standing in the threshold to the door, kind of just with her hands. The way that he did it in the interview was just kind of like her hands on her hips, as a grandmother would.
You just made a motion with your arms that I want to describe and make sure is accurate. You've sort of closed your hands and placed the tops of your hands on your hips with your elbows out at an angle. Is that correct? Does that describe the way that he said Theodore was holding her arms?
That's how he displayed it in the interview.
Very good. What did he say happened after that?
He said that he came out and that they continued their quote unquote.
What happened next?
He says that Deidre lunged at him. He grabbed her, spun her around, disarmed her.
When you say disarmed her, what do you mean?
So he did a reenactment with Detective Rice, and then he said that he knocked the knife out of her hand.
What did he say he did after he knocked the knife out of her hand?
He put her in what I would call a rear naked choke. So he demonstrated putting his arm around Deidre's neck, and that she was able to escape from that. Then she turned towards him and tried to claw at his face. So he grabbed Deidre around the throat, both of his hands, and strangled her until he got her neck.
Did you ask him if he had been hurt during this at all?
Yeah.
What did he say?
He said that he had some scratches on his arm, on his left arm. He also gave alternative explanation for it, that either being the dog had scratched him on a Monday. He at one point said maybe the knife, that he recanted that it was the knife that either the dog or teacher had scratched on their hands.
You described a few moments ago that he had put her in what you called a rear naked chokehold. Could you describe exactly the positioning of their two bodies that he said that they had while he strangled her with his arm?
So a rear naked choke for me would be his arm was below her neck, coming around, cutting off the airway, or the neck. Her back would be against his chest, so she would be facing away from him and he would be directly behind.
What did he say happened after Theodora? Well, he said he strangled her until he felt her neck snap. What happened? What did he say happened after that?
He drove her body to the back of the basement, where there was maybe a storage or wine cellar area, which kind of like a very area with shelves. He laid her against the wall. And then later he put her on top of the quilt in that area. He waited till it got dark, and then he carried her up the stairs. His explanation for that was that she was heavy. He went outside, and in the area where the garden had been previously dug up for some hostas, or other plants. He just left her laying there on the ground and then dug the hole so that it was big enough for a teacher to fit in. And then
May I have a moment, Your Honor? I'll pass the witness.
Cross-examination.
Good afternoon, ma'am.
Yeah.
How long you been a detective?
21.
So you've been trained on taking statements from suspects in custody? One of those things you've been trained on is when a suspect's in custody, before they can be interrogated, they must give a waiver of their Miranda rights. And that waiver, you've been trained, has to be voluntary.
Yeah.
And the individual has to understand the rights that they are waiving.
Yes.
Is your testimony before this court today that when you saw Mr. Fleming Jr., the defendant, were you able to observe him?
Yeah.
You were able to observe his mannerisms?
Yeah.
You were able to observe his speech? And you believe that he was of competent mind to waive his Miranda warnings?
Objections to that.
Sustained. Sustained. As to the phrasing of the question. Go ahead.
Did you believe that he understood his Miranda warnings? You didn't see anything to alert you that he may have some sort of a mental illness or mental situation prohibiting him understanding those Miranda warnings?
Fleming stated that he had some college education, that he had not been drinking, and that he had stopped smoking marijuana so that he could gain employment.
And at this time, I'd ask the court to take judicial notice that Mr. Fleming Jr. has been found incompetent. It was at the forensic center, I believe, according to the court file, for close to a year.
Your
That-
consent to
that-
restore the competency.
That he's since been restored.
He's since been restored to absolutely.
But you're asking me to take judicial notice of the competency timeframe?
Yes, Your Honor. One of the things,
But you're not asking me, because I couldn't, to make a finding regardless of that as to his competency on the date and time that he's questioned.
no, but you couldn't do that, but I will be asking you to take that into consideration in evaluating the statement. The court can, when evaluating the statement of defendant, consider circumstances surrounding this. One of those circumstances would be his mental state.
Yes, but you're asking me to, I think, take his competency as a way of indicating that I would be basically adjudicating his competency on the date and time that he's questioned, based upon what was a finding that happened later.
Yes, Your
I
Honor.
don't think I could do that.
If that's court's ruling, yeah, we accept that.
Okay.
Yep. No further questions, John.
Any redirect?
I have a redirect, Your Honor.
You may step down. Thank you. Additional witnesses.
No additional witnesses, Your Honor, expressed.
No witnesses. All right.
Your Honor, people do request the court bind over the defendant on the sole count of open murder for the death of Theodore Fleming. I do believe that we have established by a probable cause standard that the defendant did cause her death. And I ask the court bind this matter over for further proceedings. I'll reserve any further argument for rebuttal.
Right.
Yeah, we'd ask the court to not bind over again. We rely on two reasons. We believe here the warrantless entry into the home of Mr. Fleming Jr. can only be justified under the emergency aid exception. Now, the emergency aid exception allows police to make a warrantless entry into a dwelling in which they reasonably believe, based on specific articulable facts, that some person within that dwelling is in the immediate need of aid. They are not allowed to do anything more than that is necessary to render aid to a person who may need aid. Here, the responding officer, based on the testimony here, we would concede that the initial entry into the home was under an emergency aid exception. He received information from family members saying that they hadn't heard from a family member for quite some time, that was unusual for that family member, which is important. The court has to determine whether or not it was unusual for this family member to not be in contact with other family members for days in order for the court to render this emergency aid exception valid. And then the officer goes in and does a check to see if there's anybody in the home that needs aid. There is not. At that point, the officer has done everything that is necessary to determine if there's somebody in that home that needs emergency aid. Now this is a criminal investigation. He is suspicious about the whereabouts of the individual who's missing, Thedra, and he is investigating that. As part of that investigation, he goes into a backyard. He starts digging. He does not have consent of anybody that has standing or authority to grant consent to dig in that backyard. He digs in that backyard without a warrant. He makes a discovery of the body. That information is passed along to a detective who ultimately gets a warrant, but based on the questioning of that deputy, the substantial majority of the information that came from or that went into the affidavit came from the people who were at the scene and would have come from the unlawful digging and warrantless digging into the backyard. So any argument that inevitable discovery would apply to the discovery of the body, I don't think can stand. Your Honor, we'd ask the court to suppress the discovery of the body in this case because the officer clearly acted outside the exigent circumstances exception when he started digging in the backyard. There is no reasonable argument anybody can make that the officer thought that somebody needed emergency assistance when he started digging into that backyard. And the courts have been clear there is no homicide exception that applies to the exigent circumstances or warrantless search exception. Secondly, Your Honor, we'd ask the court to not give any credibility to the statement given by Mr. Fleming Jr. To the detective. I think the court can looking at the circumstances surrounding the giving of that statement, that my client was not in a position in which to credibly make a decision to speak to police and waive his Miranda rights, Your Honor. Thank you.
Thank you, Your Honor. I will start by acknowledging that I think defense counsel's asked for suppression
Of evidence based on the lack of a warrant for the initial discovery of Theodra's body. The question before the court, I know the court knows, is of course bind over on the homicide. So I don't know that I understand defense counsel's request and his argument, but I do believe that the suppression issue will be fully litigated in circuit court.
Yeah, but that doesn't mean that the defense can't raise it at some
100%.
point, because if I were to agree with the defendant, then there may not be probable cause to bind the defendant over.
Yes, Your Honor.
Yes, certainly.
And we appreciate it coming up, and I anticipated this issue coming up at this level as well as when we get into circuit court. I will say that there is more than one exception that applies and that people would allege apply. First of all, consent. The first initial search of the home when we talk about our consent exception is done with somebody that appears to have authority. Your sister has a key to your house and she hasn't heard from you. She can give consent to a police officer to go in as a community caretaker, as agent of yourself, to look for this person. So I do believe that the search with the initial house would be fine for consent, as well as the secondary search. When the defendant, Ms. Tony Curry and Mr. Ronald Sr. are all asked if he can look again, and the defendant, in fact, locks the dog up in the run and goes ahead and looks. Also, Your Honor, I think that it is important to consider the exigency of the situation. This is an elderly woman. No one's heard from her in days. Her phone is full of missed calls, full of unanswered text messages, emails, all these sorts of things that the detective Rob did indicate to the court. So I think it's important for the court to consider that there is an exigency element here. We don't know where Theodra is. We're looking for Theodra. At the time that he's speaking with Detective Rob, at that time, the defendant is the only person in the home. He hasn't seen Theodra. He doesn't know anything. He doesn't know where she is. He hasn't heard from her. And it's concerning. We are not sure where Theodra is. I do believe that we have sustained our burden. I think that we do have at least more than one exception to the warrant requirement that would apply here. And inevitable discovery is one of them. Theodra would have continued to be missing. There would have continued likely to be more investigation, more police contact, more police involvement in this case. So I do ask that the court bind this case over and allow us to proceed to trial in the circuit court.
Yes, sir. If the prosecution was to argue community caretaking actually has a higher burden than exigent circumstance. Exigent circumstance is reasonable belief. Community caretaking is probable cause. And for community caretaking, they have to show that these officers believe that there was an ongoing emergency and a danger to the public. There is clearly no testimony that they believe to that. And the deputy testified he did not ask for consent before he started digging. So there could be no consent to that portion. We conceded in our
Would consent to access to the premises have to be to every act?